of the Supreme Court Act. Full stop. If they want to bring a new case, as I say,
they don't need to specify the provision. They don't need to do so. If they make out a proper case on the papers that the decision of the IEC is unlawful, then this court would be entitled to review that decision and to set it aside. And the court will have to be concerned about the consequences of setting it aside.
Well, my lady, okay. Well, I don't know if they can really do that. If they can say, let's assume they can say it's a legality review, as the leadership was saying earlier, successfully. All I'm saying is that it's going to run into the same end of the road. That yes, it's a legality review of what? Of a decision of the Deputy Chief Executive. That decision is not reviewable.
And that's a jurisdiction point. Right?
No. It's now a substance point. I'm saying the decision of the DCEO is not reviewable before this court. And that's what Mr. Mukhale was trying to say in the morning when he talked about immunity. He mischaracterizes our argument to be saying, therefore, that means that a decision of the DCEO is not reviewable, will never be reviewed. I think that's what he said. No. How could we make such a ridiculous submission? Of course, that decision is at a theoretical level reviewable, but you cannot review it directly. It must first be a decision of the Commission. And how does it become a decision of the Commission? By the process of either an appeal or whatever referral. Of course, there's nothing, how can we say the decision is immune? There's no such thing. Even if it was a decision of the person who sweeps the floor, it can be immune from review per se. But the Act has prescribed what kind of decisions should be. It's like, my lady, I say an accident happens in Durban, and then we say, no, this court doesn't have jurisdiction. And they say, oh, well, it means then you can just break my leg and I can never get recourse. No, you are just in the wrong court. You are, the harm that you have suffered is obviously justiciable.
Of course, but if this court finds that it lacks jurisdiction over the relief sought, it's the end of the matter.
That's it. Yeah. That's the end of it. That's why I was saying, my lady, one cannot conceivably reach the merits. In Makanya, this court said, the SCA, said that one must not mix up the merits of the case. Let's say they have the best, the most brilliant case in the world. One must not mix up that question with the question of jurisdiction. The question of jurisdiction is not whether you're going to win or you're going to lose. It is whether the court has the power to enter to hear you in the first place. And Daba, this court, no, not this court, the Constitutional Court said in Daba, the best way, at paragraph 75, the best way to judge that question is to go to the pleadings, where you look at it, but the one cannot move. Then quickly, let me run to the issue of, the leadership is quite correct, that should be the end of the case. But let's quickly go to condonation and agency. I'll do them interchangeably to save time, but because they are related. But here's the mistake that everybody makes in this court. When we talk